Very good evening, my dear friends.
Yes, sir. Good evening, sir. Good evening.
And then today we are going to discuss about two vital doctrines. And then the first doctrine is called the doctrine of constructive notice, and the other one is called the doctrine of indoor management. The doctrine of constructive notice goes on the presumption that the outsiders to the company are presumed to have read and understood the memorandum and articles of association, and then later on they cannot express ignorance. Whatever may be the pros and cons they are supposed to bear. So, this doctrine protects the company from the outsiders. And exception to this doctrine is the doctrine of indoor management, where the internal aspects are concerned, the outsiders are not expected to know so that they are protected. So the doctrine of constructive notice protects the company against the outsiders. And the doctrine of indoor management protects the outsiders against the company. This is the way the concept goes. Two important concepts. Friends, we will start off our discussion with the doctrine of constructive notice with the Bombay High Court judgment T.R. Pratt, P-R-A-T-T, Limited versus E.D. Sasson and Company Limited, Bombay High Court 1936. In this case, the Bombay High Court held that every outsider dealing with the company is presumed, deemed to have notice of the contents of the memorandum and articles of association. They cannot later come and complain that they are not aware of the contents. It is presumed they have read it and understood it, and then anything happens ultimately would be their responsibility. And if they suffer a loss, it would be at their own peril. And ignorance of law is no excuse. Ignorantia, law, non exit. Same principle applies here. This is called the doctrine of constructive notice. There are a number of documents which are supposed to be filed with the register of companies, and they are all available for copies also. For example, the memorandum and articles of association of the company compulsorily registerable, the charges, special resolutions, the annual returns, and then the master data. So, going by all this, the corporate affairs that they would be known to the outsiders. They can understand what is happening inside, and who are managing it. And with this particular background, the outsider will have to take necessary care and caution while dealing with the company. That is the reason why this doctrine says that it is presumed that, or it is deemed that, the outsiders have the knowledge of the contents of the memorandum and articles of association because they are public documents, and they can see, like I told you the earlier example, a company is having the objects as gunpowder or face powder. They can go through the memorandum, they can ask the company, otherwise they can go to the register of companies and find out. So this is not done. It's a serious lapse on the part of this particular outsiders dealing with company to enter into any contractual relationship, and any loss suffered, it would be their own responsibility, and the company cannot be held liable for any such kind of exigency. So there is one more citation, Mahoney, M-A-H-O-N-Y, Mahoney versus East Holyford Mining Company, East Holyford Mining Company, 1875, where the court said that it is presumed that the outsiders read the memorandum and articles of association, they have got the knowledge of these particular documents. Then, friends, there is another Indian court's decision, Madras High Court, 1934, Kotla Venkataswamy versus C. Ramamurthy. Kotla Venkataswamy versus C. Ramamurthy. In this case, the court held that it is presumed not only that the outsiders have read the memorandum and articles of association, but they have understood the contents also properly. This is the most important thing. The facts are very interesting. In this case, the articles of association contains provision that all deeds documents must be signed by the managing director or secretary or a working director on behalf of the company. And a mortgage deed was signed by secretary and the whole-time director only, but not by the managing director. So the articles are binding, as I told you already. So the court held that the whole transaction is void and then it has no effect. So outsiders tomorrow express ignorance and they sue the company. The company is protected from the outsiders by invoking this doctrine of constructive notice. This is lawyer's paradise with regard to protecting the interest of the company, and the corporate lawyers have to be necessarily familiarized themselves with this particular citation and with this particular doctrine. Then, friends, for this particular doctrine, there is an exception. That exception is called the doctrine of indoor management. What is the meaning of indoor management? Within the four walls of the company, what transpires, what happens, and ultimately what would be the result. I don't have access, for example, as an outsider, then I am not expected to know. So there are certain things where they are presumed. If ordinary resolution, it is not compulsorily registrable. Only special resolutions are compulsorily registrable. So I don't have the access to know whether a resolution is passed or not, whether a particular activity has been carried as per the dictum of articles of association or not. And the company has several contracts, daily basis sometimes, and then in that event, several outsiders come into picture and it may not be possible to know. So what happens in the four walls of the company, outsiders need not know. That is where the doctrine of indoor management protects the outsiders from the company. Doctrine of, I repeat, doctrine of constructive notice protects the company against the outsiders. The doctrine of indoor management protects the outsiders from the company. This is a twofold point, and two doctrines come together, and the other doctrine is the exception to the doctrine of constructive notice. In this case, it is ultimately the concept says that the outsiders are entitled to assume that as far as the internal proceedings of the company are concerned, everything has been regularly done. And then if they don't have knowledge of that irregularity, then they are not liable. So even though they are supposed to read and understand the memorandum and articles of association, it is presumed they have read it and understood. They need not inquire into the regularity of the internal proceedings. The reason being, we don't have access as outsiders. No company would allow any person dealing with to verify the registers or board meeting minutes, shareholder meeting minutes. Naturally, it is internal document and it is confidential. Only annual returns you will get certified copies from the register of companies. So wherever special resolutions are there, charges are there, whatever is supposed to be compulsory registrable with the register of companies would be secured because they are public documents. Otherwise, it is not possible. So that is where this particular exception has come. That is the doctrine of indoor management. The doctrine of indoor management was laid in the rule in Royal British Bank versus Turquand. Turquand, you can say Turquand, 1856. Friends, in this case, the directors of a company issued a bond to one outsider T, and the directors had the power under the articles to issue such bonds, provided a resolution was passed in the general body. And in this particular case, no such resolution was passed, and then ultimately this particular T purchased the bond, and subsequently there was a failure. Then he sued the company. Then the directors took the plea that this is they are deemed to have read the memorandum and articles. Then the court said what transpires within the four walls of the company need not be known to the outsider. And here this is something confidential with regard to the shareholders meeting. Outsiders are not allowed to go through the minutes, and unless it is a special resolution, it can't be in fact known also from the register of companies. Master data does not reveal. So taking that, it was ultimately held that this outsider depositor, bondholder, could recover the amount of the bond as he was entitled to assume that the resolution has been passed. So the rule was based on public convenience and justice, and then ultimately it has become a universal principle. Friends, this rule was subsequently followed in the case of Fountain, Foutaine, Fountain versus Carmarthen, Carmarthen, Carmarthen Rail Company, 1868. So, friends, now you understand this is a very specialized subject matter we are discussing. Outsiders dealing with the company are expected to have the knowledge of memorandum and articles, whether they read it or not, and then it is immaterial. It would be at their peril if they have not done it. The exception is they are not supposed to know the indoor management, internal aspects, that is Royal British Bank versus Torquand. And in the event anything happens internally for which I have no access to know as an outsider, then I would be given necessary relief and then compensation also as per the circumstances of the case. Now, this is the basic principle is constructive notice. The exception is indoor management. Now we are going to discuss the exceptions to the exception. That means under certain circumstances, this particular exception, that is the principle of indoor management, does not apply. And again, the company will be put on the protective mechanism from the outsiders. What does it mean? Exception to the exceptions. Doctrine of constructive notice, main principle. Exception is indoor management. Now, exceptions to this exception. If the exceptions apply, this indoor management concept will not apply. Then constructive notice will apply. What does it mean? Number one, the first exception is knowledge of irregularity. This is an English case, Howard versus Patent Ivory Company, 1888. The serious company cases will in fact contains all these particular cases. In this case, the directors were permitted to borrow up to 1,000 pounds without passing a resolution, but they have gone beyond 1,000, and then ultimately they have gone beyond 1,000 and no resolution was passed here. So 1D outsider lent over 1,000 pounds. Then the court of law said the company is liable to pay up to 1,000 but not beyond. The reason being, there is a specific direction. The borrowing powers are stated in the articles, and they say borrowing powers up to 1,000 crores. So when I am investing more than 1,000, I should have got inquired and then found out whether a resolution is passed so that they have power to go beyond. Here, they have to pass a resolution if they want to go beyond 1,000 pounds. But the directors did not do so. So this is a lapse. So knowledge of irregularity. It is got nothing but collusion. So the court of law held that this particular person who dealt with the company was having knowledge of irregularity. And in that event, this doctrine of indoor management does not apply. Doctrine of constructive notice applies. So that whatever he paid beyond 1,000, over and above 1,000 would not be secured, up to 1,000 would be secured. I feel it's a very justified judgment. Now, the second point, negligence. Second exception is that if an inquiry is needed under the circumstances and it was not done, it is a lapse on the part of the particular outsider. In that event, it comes under negligence, then this doctrine of indoor management shall not apply. The citation is Anand Bihari Lal versus Dinshaw and Company. Anand Bihari Lal versus Dinshaw and Company. Then, friends, the third exception, acts which are void ab initio and involves forgery, right, would not entail the application of this exception. In the event there are acts which are basically void ab initio, then there is no transaction. Doctrine of indoor management will not apply. I told you always companies' properties are protected, companies' interest is protected, even in illegal transactions. I gave you the telephone company example last time. Same is the case here also. So, acts which are void ab initio and which involves also forgery would not entail the invocation of doctrine of indoor management. Constructive notice only will apply. You can take down the citation. This is Reuben versus Great Fingal Consolidated Company. Reuben versus Great Fingal Consolidated Company, 1906. Then, friends, the next important thing is acts which are outside the scope of apparent authority. Wherever there are acts which are outside the scope of apparent authority, then this particular doctrine of indoor management will not apply, because apparently it is to the eye that this particular act is not within the scope. If it is very clear, then you have to make necessary inquiry as an outsider, so the lapse is on you. However, there is an exception to this particular exception. Constructive notice, indoor management exception. We are studying exceptions to this exception. To these exceptions, there is again another exception. That means indoor management will apply. How does it apply? If the company, in fact, the officers of the company, they indulge in such fraudulent acts under ostensible authority on behalf of the company, then to the outsiders, this particular doctrine of indoor management will not apply, then the constructive notice will apply. Doctrine of indoor management will apply and doctrine of constructive notice will not apply. I repeat, if the officers of a company are acting fraudulently under ostensible authority, earlier I told you fraud, that is forgery, where there is collusion and involvement of the outsider. Here it is not the case. Here it is the officers of the company who indulged in the fraud, and then they have done such acts under their ostensible authority on behalf of the company. Then what happens is this particular doctrine of indoor management will apply, and then constructive notice protection will not be given to the company and protection will be given to the outsider. I will give you a small example. Sri Krishnan versus Mondal Brothers and Company. Mondal Brothers and Company, 1967. In this case, the manager of a company had the authority to borrow money on behalf of the company. And he borrowed the money on hundis, but he did not credit the amount to the company's account, but he credited his personal account. So the court held that this particular creditor can recover this money from the company as a receipt was issued, money was collected, and then company is bound to return. Here they can't take shelter under the doctrine of constructive notice, and the officer's fraudulent acts are in fact will not exonerate the liability on behalf of the company. The company is vicariously liable for all the acts, tortious deeds of its employees. In that event, this particular doctrine of indoor management will apply, and then necessarily relief has to be given to the affected persons. So, my dear friends, with this particular background, I have concluded my discussion on the indoor management doctrine of constructive notice, for which exception is indoor management, and there are exceptions against applying the doctrine of indoor management. And last point is exception to these exceptions, where again indoor management doctrine will be applicable and constructive notice doctrine will not be. So in the examination point of view also, you can get a 20 marks question, then necessarily you will have to answer it in this particular fashion. You explain the principle. Here it is not statutory provisions, but it is only a judicial precedents, that is stare decisis, that is doctrine of precedents. So based on that, you have to mold your answer and then study, and then by the time examination comes, if any other new law comes, keep clicking and watching. Any other judgment comes by the Supreme Court and then our local Telangana High Court or Andhra Pradesh High Court, probably you can take them, and then you can also put the particular latest judgments. Mostly, I find if today also I checked up, memorandum and articles of association are concerned, basically same principles, same doctrines, and then same old cases. To my knowledge, new cases at the moment are not there. In fact, I have been checking up. You can also keep checking. Anything is there, we will share it, and then we will, in fact, upgrade our knowledge. So, with this background, friends, I conclude my discussion on this particular doctrine of indoor management. I mean, constructive notice and indoor management. And then we will again meet on Wednesday, because now unit 2 is over, 1 is over. We will take a little break. I will keep sending some good material tomorrow and after tomorrow. Then Wednesday, as usual, at 6:30 we will meet. Then start off our discussion on the prospectus, the loan capital of the company. That would be in the third unit. This is what we are going to see. Step by step, we will cover the third unit and then go to the fourth unit. We have got last working day, 8th August. Until then, we will be meeting by and large regularly or intermittently 1 or 2 days break. We can continue. So I thank you very much. We will meet again on Wednesday. Tomorrow, day after tomorrow, we will take a break. Thank you. Good night.